Welcome to the Neighborhood Law Center. I'm your host, Melvin Burris, and tonight our guest is Attorney John Grimes. Welcome, Counselor.
Good evening. How are you?
Okay, before we get started, would you like to give our audience tell our audience a little about yourself and the subject we're talking about tonight?
Okay. Well, I'm a practicing attorney. I've been practicing law since 1973. Since 1989, I've been devoting almost 100% of my time on divorce and matrimonial law, family law matters. And I'm trained, I received training within the last 5 years in mediation and collaborative divorce.
Okay. All right, well, let's get started here. I know the last time you were here, you talked about divorce and litigation.
Yes.
Tonight, we're going to be talking about divorce and collaboration as well as mediation. Now, before we get into it, could you tell our audience a little about the difference of the two and what each one of them are?
Sure. Well, mostly everyone is familiar with litigation. You appear before a judge, you have a trial, the judge makes a decision. Mediation and collaborative divorce, that's an alternative to litigation. When you litigate, you're presenting all of your facts before a stranger, and this stranger is a judge. And it's the judge that will make a decision that will involve your finances, your children, the custody of the children, and things way down the line. Whereas in mediation and collaborative divorce, it's the spouses that really would come up with a decision as to their future. And it can be something that's really fundamental, or it can be something that's outside of the norm that a judge will normally have to do, because a judge is only limited by the law and the procedure in New York. Whereas in collaborative, you can do anything you want.
Okay. Well, who is this person who's the mediator? Let's talk about mediation first. Run us through what the mediation process is, and how do you appoint, or how do a person who's going through a divorce pick a mediator versus going to an attorney?
Well, normally, let me just handle this as if someone is walking into my office and it's clear that they want a divorce. What I normally do is, I sit down with them and I explain the different options, and I display to them a chart that I've made up that would explain and show the process on the various alternatives. Now, we'll start off with mediation. What mediation is you have a trained mediator. That's someone who's trained in mediating divorce matters. And in the mediation, you have the two parties that would appear with the mediator. The mediator is a neutral, cannot take sides. And basically, the mediator would guide the couple through the divorce process. So you would be sitting at a table, let's say it's a round table. I'm sitting in the middle, and we have the wife on one side and the husband on the other side. And I will explain to them the mediation process. And if they agree to that, then we sign an agreement and we'll start the process. And basically, the first thing I want to get from them is just what are their concerns and what are their interests, and how they feel they can get from being a couple in conflict to the ultimate divorce. Now, the mediation process, it's just a number of sessions, and it's determined by the problems or the issues or the interests that the parties come up with during this process. As we navigate through the mediation process, the ultimate end result would be they're in agreement, and it's time for me as a mediator to start working on a settlement agreement or a separation agreement. I will draft that, and once that's done, based on what we agreed to over the various sessions, this would then be the semi-final document. I would give it to the parties, but I would also caution them. I'd say, I'm an attorney. I prepared this. However, I would suggest that the both of you would just consult with an independent counsel to review this agreement to see if this is actually meeting your interests and needs. Once we go through that process, the parties can decide if they want to get a consulting counsel or not. I've represented clients in a mediation where they decided not to have it, and I've also been a consulting counsel in mediation. So once the agreement is set and everyone signs it, then we can proceed with the divorce. In New York, the divorce has to be signed by a judge of the Supreme Court. So it does go into court. However, the parties do not appear. The attorney would prepare all the papers, submit it to the court, and then we have a signed divorce judgment.
Agreement. Okay. Okay. But for which kind of disputes would a mediation be appropriate?
Well, there has to be an agreement, and the same with collaborative. There has to be an agreement between the parties that this is going to be a non-adversarial process. Okay. Collaborative goes another step further.
Okay.
And if you want me to go into that, I can now.
Well, I just want to ask you,
sure.
Will the mediator meet separately at any time with the divorcing couples?
No.
Okay.
Because that would take away the aura of neutrality. The idea is to have me as a mediator be a neutral. There may be some rare instances where the parties may agree and say, meet with alone with John Grimes, but normally no. Okay.
Now, who pays the cost? Is it split, or is it they agree that one party will pay?
Well, since this is mediation, they would decide how the payments will be made.
Okay, and they also will decide their financial situation.
Correct. Now,
go ahead.
If it is a complex financial situation, or if through the mediation process, I see that maybe the husband or the wife is more versed in finances, I would suggest that they speak to a financial neutral and bring that person into the process just to help the spouse that isn't really up to it, give them an idea and to help them along.
So in mediation, people have to really be honest with each other.
Oh, absolutely.
As far as the finances are concerned, as far as the children are concerned, because if one has a pension, the other doesn't, or someone has more money than the other, these things have to be brought out.
It has to be complete transparency. And as far as what the finances are, what I always insist is that each party prepare a net worth statement. Net worth statement is something that's required, in litigation, and I would give each party the necessary documents to complete this. And again, if there is a problem with one party, I can't really do this, then you'd have that financial specialist come in.
Okay. Now, the agreement we talked about, is that binding on both parties?
Absolutely. They both would sign it. It would be notarized, it would be acknowledged, and this is a binding contract.
Okay. And if they can't agree, as you said before, what's the next step?
If they can't agree?
If they cannot agree.
In mediation, well, litigation.
Okay, so then they go back through the
But the whole idea
process
is to try to navigate this process so it would not jump into the adversarial stage.
And, okay, so now, let me understand that, because there's so many elements of a divorce, visiting rights, when a child stays with one person, if their children are involved, different things like that. The grandmother has visiting rights, and all these things are discussed and talked about. Do you have a chart or elements that you go through? Because sometimes people can't think of everything that's going to occur in the future based on this divorce.
Well, no, as we go through the mediation process, if there are children and they're going through the process, of course, I'm going to say, you have children. What are your interests? What are your concerns? What how do you plan to go through with the children if they're young, through elementary school, high school, marriage, because clearly if you get divorced, it's not a complete breakup, because if you have children throughout the years, you're going to be involved. There's going to be graduations, you might even have bar mitzvahs, you have marriages, you have deaths, and all of these occasions bring family together. So you can't say, once you get a divorce, I'm not going to see this person any longer. And then there's the issue of child support and maintenance.
You're right. All these things come out.
Absolutely. All of these things will be discussed and in detail, and the parties will agree. They would, one party would, let's say one spouse says, I don't want to pay maintenance, and the other spouse says, I want the world. So, these will be two things that's apart, and I would try to bring it together. And we would explore various options that would bring them to a point where there is agreement.
Okay, let me ask you this, because I'm thinking about relationships. If a person has been in an abuse relationship, it could be the husband or the wife, either one of them. Would you recommend mediation for that type of relationship?
I would initially have to listen to the parties, but more I would say no, because in an abusive relationship, you have one party that's really the power person,
the dominant,
and therefore you really can't have a mediation where the parties are coming to an agreement, because you'll have one person dictating the terms, and this can happen even if there is not an abusive situation. And if I see this in a mediation, I will have to bring this to the table and make a suggestion that, hey, maybe we have to bring in another party here, meaning maybe a mental health specialist or something like that. Or if it's something I see that's untenable, court.
All right. Well, now the next thing is costs. We're paying for the mediator. We now have to get our, as you suggested, the independent counselor to review the agreement. Now, this get pretty expensive after?
Not necessarily.
What's the comparable? I mean, do you?
Well, again, they don't have to have this counsel. However, I think I can bring this more to light when I discuss the collaborative process also, because the collaborative process has many more heads involved.
Okay. Well, let's go to the collaborative.
Okay.
Okay. So we move on to that.
Okay.
Right. Why don't you explain to us what the collaborative process is and collaborative law?
Okay. Collaborative, like mediation, you have the parties. However, now each party would have his or her counsel. And this counsel, the lawyer, will have to be trained in collaborative divorce, as well as anyone else that's brought into the process. They would have to have the requisite training. Now, one of the beauties of collaborative divorce is that initially, when the parties meet for the first time, they're given what's called a participation agreement, and that spells out the collaborative process. But what's critical in this participation agreement is that there is an agreement with the attorneys that if the collaborative process breaks down, these attorneys cannot, or anyone else involved in the collaborative process, cannot be involved in a litigation. So, if we go through the collaborative process, it breaks down, the husband and wife would have to get new attorneys.
Start all over again.
Basically. Unless there's some point in the collaborative process where there is agreement, then they can take this agreement to the court and they don't have to, start from that point. But it's up front. The parties have to realize that this has to be completely transparent. Everything has to be on the table. There can be no holding back. Now, in this process, it's recommended that it would be a team process, meaning that there would be a coach for each person or one coach for the two. And a coach is a mental health professional. The purpose of this person is to help the parties navigate through the emotional terrain of a divorce. Because I don't care what you say, when parties decide that it's going to be over with, there's emotions involved.
Right. Exactly.
Maybe it starts off with one party wanting a divorce. Maybe a third person is in the picture. But no matter which way you go, there's the emotions. So you bring in this coach or coaches, and the parties will make that decision.
Now, who recommends the coaches, or where are these coaches?
I would never recommend a coach. What I would do,
you as the collaborator.
I'm the lawyer, so
Right.
I have a client, husband or wife, that wants a collaborative divorce.
Okay.
So I would either recommend give them a bunch of names, or recommend them to some of the professional collaborative groups. There's a New York Association of Collaborative Professionals. There's the Hudson Valley Association of Collaborative Professionals. There's the Westchester Rockland. So there's lots of collaborative groups. And in these groups, there are professionals trained in collaborative.
Now, they would meet separately or together with these coaches.
Yes.
To select one first.
Of course.
Yeah.
It's everything in the collaborative or mediation is driven by the husband and wife. The lawyers don't drive it, so they come up with their own solutions. They're the ones that's negotiating at the table, and that's where the coach would come in. If you have a weak spouse that doesn't really have good negotiating skills, that's where the coach would also assist. And the beauty of this is that if you sit down with a coach, which is a mental health professional, their hourly rates are nowhere near the hourly rates charged by a lawyer. So they're getting assistance, but they're getting it at a much lower hourly rate. Now, also that's brought into this picture is the financial specialist that I mentioned before, to navigate the financial ups and downs, because every marriage develops assets of one sort or another. Oftentimes, some clients are very surprised to learn that, hey, this pension that I've been contributing to and my employer has been contributing to, that's a marital asset. Also in New York, if you happen to get a degree during the course of the marriage, that's a marital asset. And you would get an expert to put a value to that. Advanced degrees would give rise to an enhanced earning potential. So an expert would look at someone, let's say, with a bachelor's degree and someone who's a doctor, and you have a chart where over the course of a lifetime, a bachelor's degree goes here. Over the course of a lifetime, a doctor's salary goes this way, and this portion in between, that's the enhanced earning that an expert would put a value to, and that would be divided as a marital asset.
Okay. Now, I mean, is there any situations, people sitting down and talking about their situations with a third party, I think is very healthy. And are there any situations where people have started talking with a coach and then all of a sudden decided, well, we don't want a divorce?
Oh, absolutely. I mean, that would be the ideal situation. I don't go into a matter with a client saying, hey, the ultimate goal is to get them out of this marriage. If there's some way they can reconcile, I consider that a winner.
Yeah. The other side of coach, we talked about it earlier, is that if they have kids involved, is there a coach for the young kids, or somebody can talk for the kids and what they feel about divorce?
Sure. And what I do when a client comes to my office, or I have both spouses, I have a little chart that I show them, and it goes through the various processes, other than litigation. And then on this chart, when we get to the collaborative portion, I'll explain to them, litigation and what's involved. I'll explain to them that sometimes parties can sit across the kitchen table, and that's on my chart, and they come up with a solution and then come to me, and I'll do an agreement. But when we get to collaborative, I have this, we look at the chart, and you see a whole bunch of different players. You have the attorneys, you have the husband and wife, you have the two coaches, you have a financial specialist, and you also have a parenting coordinator. And the parenting coordinator acts as the voice of the children or the child, because you do not bring the children into the collaborative process. Now, this parenting coordinator, again, is someone who's trained, a mental health professional, could be a psychologist, a psychiatrist, a social worker, but someone who's, trained to deal with children, and also someone who's trained in collaborative divorce. So now, when I present this to a client, the first thing they say is, wow, there's a lot of, you have to pay each one of these.
Yeah, right.
Okay?
Right.
And
what is your response to that?
okay, and I tell them, not necessarily so, and I give them experiences in litigation that I've gone through, where, again, in collaborative and mediation, it's the parties that will determine where they want to go, how they want to go, how often they meet, how long the meetings are. If you're in litigation, everything is governed by the court. So the first thing in litigation, the judge would direct a preliminary conference, and everyone has to show up in court. And in Westchester, you meet with you do not meet with the judge. You meet with a court attorney referee. But, that can take anywhere from half hour, 45 minutes to maybe over an hour. However, when you're told to be in court at 9:30 a.m., your case is not going to be called at 9:30 a.m.
Right.
And you have to remember, most lawyers, they bill on an hourly basis. So I'm charging X number of dollars an hour, and this case may not be called until noon.
Right. Second call.
Or third call. I mean, I've been, just a few months ago, I was in court and we weren't called until 4 in the afternoon. Meanwhile, the client is billed for that time. Whereas in the collaborative process, you have everything planned and directed by the parties. So if they go meet with a coach, they'll meet for an hour or a half hour. They'll bill at this lower rate. I'm not involved. But then we may have a meeting where the 6 of us will be at a table. But again, in the long run, it usually is more economical and is good for the mind.
It's almost, you're saying that in the mediation or collaboration, you can almost cost it out. Well, based on the hours that you estimate that you're going to use. Whereby if you go to litigation, it's very difficult to.
You have no control over the time.
You have no control of the
None
cost.
whatsoever.
So if you have X number of dollars and you say this is what I can use for my divorce, then you can basically cost that out to fit into that parameter.
And well, basically what the clients would do if they have a tight budget, they can say, hey, look, we're not going to meet more than an hour next week. And also, after the meeting, they can say, hey, I see we're making progress. Let's leave us alone. We can go home and kick around a few more things. We can call the coach or the financial expert to help us. And we'll call you, meaning me, in a couple of weeks to schedule a meeting and see where we are in this stage.
Okay. Now, let me ask you this. In your experience, the length of time of each of these litigation versus mediation versus collaboration, the length of time to complete the process, can you give us your best estimate on some of these?
Not really. I mean, I've had litigations with very complex cases that have gone 4 years or so. I've had a litigation that went about 3 years before the divorce, and then another 7 years afterwards.
Okay.
There was various disputes, but in collaboration, it depends on the issues and how quickly we get from point A to point B. Oftentimes you may have clients that say, listen, we want to meet on a weekly basis. You may have other collaborative clients that say, once a month. I've had situations where clients took a hiatus of a couple of months.
Okay.
So, but
they have control. Over that time.
Absolutely.
To either make it a 6 months process or make it a 3-year process.
Correct.
Where you lose control when you say you go to mediation or go to litigation.
Yes.
Okay. Look like we're running out of time.
Oh, okay.
I was wondering if you could just sum up the things that you think our audience needs to know about these 2 or 3 processes.
Sure. What I would suggest is that if a party is really contemplating divorce, that they explore these options. And usually, if a client comes into my office, that's the first thing I would do. I would take the chart that I have, and I would sit it in front of them, and I would go through each process. I would talk about litigation. I would talk about the kitchen table. I would talk about mediation and collaborative. And then I have lots of brochures and documentation that I can give the clients to go home and look through. And I would say, study this, call me back, and if you have any questions, and let's see what's best for you. What will work for you? In a case, if a single client comes into my office, I then would, if they decide to do mediation, I would suggest to them that I cannot do it because only one client came to me initially.
Okay.
So I would say, therefore that does not give the aura of neutrality.
Okay.
So go get a mediator. I'll be glad to act as your consulting counsel.
Okay. Well, thank you for coming.
Thank
you
you
for being here. What we learned today is collaborative family law is a powerful and effective way for people who are divorcing to reach fair solutions and resolve their differences.
Absolutely.
And so if you need some advice, please contact Counselor. And I want to thank you for being here.
Thank you.
I want to thank the audience for viewing in. And this is Melvin Burris. And don't forget to go to our neighborhoodlawcenter.com to see some of our other programs that we have before. neighborhoodlawcenter.com. Until next week, peace and God bless.